in prison 23 years out of the last 30 years. So I've been doing my time, and
But you
I
keep
haven't had a chance to,
to do what? Because you've been to SafeP, you've been to ISF, and you went to ISF more recently, right?
Yes, ma'am.
Okay.
As soon as I got out, I got right on probation, and I haven't had a chance to.
You got right on probation. You didn't.
Yes, ma'am.
You tested. You tested positive for cocaine after all of this time, and all the different things that have been given to you, and the opportunity that I gave you back in January of last year. You pled open, just open to me. I could have done anything. I could have sent you to prison for 20 years, 10 years, and I gave you an opportunity. And I said on that day, because Mr. Coleman printed it out for me. Well, so how do I do anything other than what I said?
I mean, the situation. I've got parents. My mother's 90 years old, man. I don't want her to die and I be.
Hey, we're not talking about anybody but you today.
Yeah, I know.
I'm sorry your mom's that old and that you haven't been around to be with her, but that's whose fault? It's not going to be my fault if you're not there. How about some personal responsibility instead of my mama's old and don't send me to prison?
Judge, what I was saying about this.
Go ahead.
He was warned about not coming back, and the court didn't want to hear about a relapse, but I don't know that this is really a relapse. He never really got the help. On this most recent term of probation with the JCDI, and if transportation is going to be a problem, I know he's already been to SafeP, Judge, but it would be a relapse portion of SafeP would be appropriate, or a whole new term.
Hold on. So if I'm reading this, I want to know when he went to ISF this last time. Parole sent him when, because the way I'm reading is you were released from ISF and started JCDI August 6th of 2024. So I put you on probation in January, and between January and August, you went to ISF last year. Is that correct or no?
Parole sent him to ISF because of this new charge.
Okay. So when was that?
He was in custody in Jefferson County, and then from custody
went straight there. So I placed you on probation. You never got out. You went and got help at ISF.
Buckle up, guys. Today we're stepping into a courtroom where a judge has clearly reached your limit. The defendant insists he spent most of his life behind bars, hoping for sympathy, but the judge quickly reminds him that prison wasn't the only thing he was given. He was also handed multiple chances to rebuild his life. Instead of accepting responsibility, every explanation sounds like another excuse, and you can already feel the patience in this courtroom running dangerously thin.
Okay. All right. Anything else?
And Judge, if the court, and it seems like the court is not leaning towards probation.
No. No.
I would point out, we understand the range of punishment is up to 20 years, but the bottom line of that range is 2 to 20. And
I still haven't done anything yet, so your response and how you act right now is going to go into what I do.
Yeah, I understand the legislation makes it possible to go all the way up to 20, but it also makes it possible to go down as low as 2. I think we have to look at each case for the facts, and the underlying offense was a theft at the Dollar General, I think, or Family Dollar. I think it was about $100 worth of merchandise. I would ask the court to consider something at the lower end of the range, maybe 2 to 5. Just because we can drop the hammer on them, that doesn't necessarily mean that we should. And that's what we're asking the court to do. Probation is not going to be an option.
Thank you. Mr. Coleman.
I'll keep it brief. The defendant has earned every bit of a 15-year sentence in prison. That's what I asked for originally. You placed on deferred. That's what I'm asking for today. 3 things I'd like to quickly point out, Your Honor. Looking at the defendant's version in the updated PSI, he says that when he was placed on in the JCDI program, that he believes it was an attempt to set him up for failure, demonstrating a lack of acceptance of his own responsibility. The resources and time that have been dedicated to this defendant, limited resources, mind you, could have.
All right, guys, this is where the courtroom turns into a battle of completely different perspectives. The defense argues that the original theft was relatively minor and urges a judge to show mercy with a lighter sentence. But the prosecution shifts the focus away from the crime itself and onto years of repeated opportunities that were wasted. As both sides make their final arguments, it becomes obvious that the judge is weighing far more than just one mistake.
Taylor, do you have anything you want to say?
Yes, ma'am, been through a lot of things in my life, people dying in my family and other things, drugs, but, I think, that I could do better if I had a chance, proper opportunity, ma'am. And I did a lot of time, I've done my time.
You have.
I don't think just putting me in prison I think I need a chance. I really do.
It doesn't make any sense because you're saying, you've done a lot of time, and at some point you either say, I don't like prison and I want to do better.
That's what I want, man.
But you didn't take advantage of the opportunities you were given. You're saying you want help, and we gave you help, or parole gave you help. So you didn't even get out on my probation yet. You had ISF, a reminder of the tools that you had a long time ago. You had those things, and you got out and you didn't take advantage of the opportunity that I told you. You better take advantage of it because you're not going to get it again. You're saying the same things that you said. Please just give me another chance. I'm going to do better. Please send me to ISF for a safe P. It's all the same thing that you're saying, and no one is setting anybody up for failure. Hang on.
To the JCDI. I had back surgery.
So what you're telling me is when did you have back surgery?
8 years ago.
Okay.
But they only did half.
Listen.
I'm not making excuses.
If you're throwing out to me that you had back surgery 8 years ago, then you are digging for everything you possibly can, and we're done with all that. I'm going to find that you previously entered your pleas of true to counts 1 through 6 freely and voluntarily. I'm going to find those counts true. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. I'm going to sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you trial court certification that shows this was not an agreement. You do have some limited rights to appeal. You can talk to Mr. Rojas about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition because of the judgment entered against.
Now the defendant finally gets a chance to speak directly to the judge, hoping that one heartfelt plea can change the outcome. He talks about family struggles, addiction, and wanting another opportunity, but the judge isn't convinced. She carefully explains that every promise he's making today is the same promise she has already heard before. Then comes the moment everyone has been waiting for. The probation is revoked, guilt is confirmed, and a 12-year prison sentence brings a hearing to its dramatic turning point.
Ms. Holmes on Demario Flukas.
Just when it looks like the hearing is over, an unexpected twist changes the mood one final time. The judge calls the defendant back before he leaves and delivers a powerful warning that she still has authority over his case. Any disrespect shown in that courtroom could make an already serious sentence